Defense lawyers have published a letter of concern about Alberta's use of the notwithstanding clause. Last week, the provincial government invoked the notwithstanding clause as part of Bill 2, which sent teachers back to work with a contract they had rejected. Invoking the clause essentially nullifies court challenges, allowing the government to bypass parts of the Charter of Rights and Freedoms. Kelsey Sitar is the president of the Criminal Defense Lawyers Association here in Calgary. So what are your concerns?
The four associations of defense counsel in Alberta, certainly within our ranks, there could be different views about the teacher strike. But what was a concern for all of our members is both the fact that this clause was invoked in the way that it was, and the procedure through which it was invoked. So the rushing of it through the legislature in just a single day. So that is what compelled us to speak out in this particular case.
So there's sort of two sides to that. Before the procedure, what's your objection or concern about it being used in this case in the first place?
Well, first of all, it's a really extraordinary measure, or at least it's supposed to be. And so for it to get invoked in circumstances when there was other routes available to the government that are far less severe, that was one part of the concern. The second part of the concern is the scope of the notwithstanding invocation in this act. So it's not just a matter of suspending teachers' rights under their freedom of association or freedom of expression, which you would expect in a striking context, but the bill actually suspends essentially all of their legal rights. So 7 through 15 of the Charter, which includes rights like the right not to be arbitrarily detained, so taken into police custody or transported to some place. It affects the right to achieve reasonable bail. It affects their right to consult with counsel if they're arrested or detained. And so the significance of the government just listing essentially every right that is protected by the Charter in what they are exempting this legislation from was really concerning.
Okay, well, that brings us to the next point too. Then, walk us through. I guess it's interesting that defense attorneys or defense lawyers are objecting to a legislative process. How did that fall short from your perspective?
Yeah, so as defense lawyers, our entire job in a nutshell is to hold the government to account. And so every day we go into courtrooms and we make sure that procedures are followed correctly and that the Crown has acted appropriately, the state has acted appropriately. And those are the types of issues that we raise. And we litigate charter rights for individuals every single day. And those of us who, may categorize ourselves as quote unquote law-abiding citizens, we have our charter rights protected and preserved on the backs of those usually who break the law. Those are the cases that go before courts and how we get definitions around what does our right against unreasonable search and seizure protect. And so we're very familiar with those sections of the Charter, and it's our bread and butter every day and what we do. And so that was the root of the concern for us, that we sort of act every day to protect the constitutional rights of Canadians and Albertans, and to see the government just broadly and sweepingly purport to override all of those rights struck us as extremely draconian. If it's that the government hasn't taken the time to consider what rights might be implicated by their legislation, maybe they shouldn't have rushed it through the legislature, and that should have been a point of debate and discussion. If it's that the government actually intends to allow police and other authorities to violate all of those rights, that's something that should be very scary for all Albertans and especially for anyone who's part of an organized labor movement.
A cynic might say something like, well, of course, lawyers are opposed to something that blocks legal challenges. I hear you putting this in broader context of your kind of mission as defense lawyers and interpreting the law. But how do you respond to that criticism?
I think that where there's a will, there's a way. So I don't know that there's always something that's completely blocked from legal challenge. And I'm sure that the ATA and others are getting legal advice on that right now. Also, a lot of that litigation is done not for what maybe the members of the public may think of as legal fees. Most of us who do criminal law are doing work under the legal aid plan in Alberta, which is a very nominal rate of compensation compared to even other professionals, people who repair your air conditioner or your garage door. And so it's not about
Yeah.
financial gain for lawyers. It's really about the principle that we have worked, and we work many, many hours a day because we feel passionately, and this job is a calling for us. And so when we see this type of state action, knowing that lots of Albertans, if they've not had the privilege of going to law school and having more exposure, they may just not understand the true implications of what's being enacted here, and especially the procedures through which it was done.
So the notwithstanding clause, it exists for a reason, and I mean it's sort of in the DNA of the buy-in to the charter across the country. So its application in this case, what's the problem with it? Like, if this isn't an appropriate use of it, what is?
Well, we've seen it used primarily, and I'll say used successfully, because there's been places that have tried to use it, and that has been struck down by courts. Or in Alberta, the last time they tried to use it, public pressure essentially caused the government to withdraw the bill that they were proposing. So where it's been invoked successfully, it's often in Quebec. And lots of times we see that either around language issues, so the need to have things in French and English, or other similar issues that are really aimed at, legislatures would say, to protect Quebec as a distinct society, which is also within our constitution, right? So it's sort of balancing out those charter rights. And we will see times where charter rights are infringed. And there are methods through which legislation can survive constitutional challenge, despite the fact it infringes individual rights. So there's already a process for that. It's called the Oakes test under Section 1 of the Charter. And I guess the classic example would be sort of check stops or ride stops, where the Supreme Court of Canada found, yes, those violate people's rights to being arbitrarily detained because you're sort of randomly selected. And it impacts your right against search and seizure because you may be asked to provide a roadside breath sample.
Yep.
But those were laudable goals because we're trying to get drunk drivers off the road and save lives. So it's not that Section 33 shouldn't exist or that it should never be invoked. There will be circumstances where the greater good is served by its invocation. The concern here in particular is the breadth of rights the government is purporting to override.
Now, we just have 30 seconds here, but what do you want to see happen now?
I want people to ask questions of their MLAs and get loud if they're concerned about this. I think there's a tendency to think there's nothing I can do, and every little action helps. So if you have an MLA that's a member of the UCP, particularly for that backbench, book a meeting. Ask them when they saw this legislation. Ask them why they voted in favor of truncating debate if they didn't see the legislation in advance. Ask the questions you have and make your voices heard.